we would ask that everyone who has submitted their assignments will present individually, and then after your presentation, we'll be calling on the mentors present to expand on your topic, and if there are things that you didn't get right, to just explain it. So thank you very much, and thank you to all the mentors for saying yes and for coming. God bless you all. So when I call you, you just introduce yourself, tell us a bit about yourself, and why you love IP and where you see yourself in, let's say, 5 years in the practice of IP. And then you go ahead to present your work. So if you like, you can share the screen and share your report. But if you're not able to, you can just present it and then we'll continue. So thank you very much. So we'll be starting with Rebecca. Hi, Rebecca.
Hi,
Hi.
Juliana.
So you can take the floor. Thank you.
Hey, do I need to go on YouTube?
Sorry, you said?
Do I need to share my detail, like, go like,
You can you can share your slides. If you're not able to, then just discuss it.
okay. Good evening, everyone.
Good evening.
Evening.
Good
My
evening.
name is, my name is Eya Oyewodi Rebecca. Um, I'm a lawyer. I'm based in Benin City, currently practicing. I was called to the bar in 2019. So technically, I'm 3 years at the bar. First of all, I'm really glad to be here. I'm glad for the opportunity. I'm very interested in intellectual property, and I look forward to learning a lot on this platform. My report centers around intellectual property as it relates to business branding. And the reason is this. My particular interest in intellectual property is as it affects digital based businesses and technology as a whole, not just the conventional practice of intellectual property, but as it relates to technology. Now, I would like to give a brief explanation of what business branding is. So, as contained in my report, business branding has to do with a process by which businesses create and establish a distinct and recognizable identity for their businesses, one that distinguishes them from their competitors. Now, this has to do with the use of trade names, trademarks, or as they call it, logos, colors, and other distinctive features, shapes, and the rest of it. Now, with the wake of COVID-19, and we saw many businesses going digital, the use of social media marketing is currently on the rise. Like 80% of small businesses in Nigeria are going digital. And this means that the branding market has expanded because to have a digital presence and online presence means there must be a level of branding to your business. But the issue is that most of these businesses, the larger percentage of them, do not consider the legal aspect of branding their businesses. Now, most business owners know they should register their business name, even though like half of them do not register in the long run or do not register within the stipulated period in the Community and Allied Matters Act. But that's like the only aspect of business structuring or branding is registering your business. They have no knowledge of trademark as it relates to their logo, trademark, color marks as it relates to their business colors and symbols and the rest of it. So my report centered around that, the fact that businesses need to consider and avail themselves of the opportunity in protecting their business branding, their branding elements, as they are rightly Now, I pointed out that businesses need to see their training as more than just the name they call their business, more than just what they register with CAC, but also what consumers and competitors, their audience, will identify their business as. Now, a trade name is actually an intellectual property, and I've come to understand that most business owners, even lawyers, do not understand this fact. So we just go ahead to register a business name because CAC requires us to. But we do not consider the fact that this is actually an intellectual property that should be protected. This is actually an element that can be trademarked also. Then on the other side, we have logos. We see people design logos. Once their name is registered, they design logos and they put out flyers and they're advertising on social media and the rest of it. And this logo is very places, really. But when you look behind the scene, you see that this logo is not protected by whatsoever means. There is no trademark protection at all. So someone else could actually pick up your logo and do whatever they want to do. I think it's because they think that registering your business means all your business elements are protected too. Your business process, your logos, your symbols, your colors, your sound, even if you have a distinct sound. But they do not understand that business registration or company registration actually does not cover this aspect. And for me, that is one aspect of intellectual property law I am very much concerned about, particularly how they share these elements on the digital space, via social media marketing, website marketing, and the rest of it. I want to be able to bring this knowledge to the face of business owners, make and brand experts also, because they advocate for branding. They help business owners through this process, but they too do not understand the legal implications of some of these things. Like if I choose a distinct color for my business, then I can protect this color as mine. If it's a creation of my business, if it's unique to me, if it's something I came up with, if there's a distinct sound I created to use in my business advertising, I can protect it for my business. If there is a logo, a shape that I have created distinctly for my business, I can protect it. Then my name, I could also protect it. So much that when consumers see this sound, see this element anywhere, they can relate it back to my business. This brings the whole essence of business is sales, right? So this brings more sales. This brings more recognition to the minds of consumers. It helps the business as a whole in the long run. And I think if I'm not able to solve this problem right now, if we're not able to create this awareness right now, then we'll have a problem making our local businesses go international. We'll have a problem of our local businesses not surviving in the international space. And let's not forget also the aspect of how it profits us as intellectual property lawyers. So even if it's for the benefit of the business, for the benefit of the sector, teaching and putting this knowledge out there and carrying out these processes for them, I think, in my opinion, and from how far I've researched, I think it's also an opportunity in the intellectual property space for lawyers who are looking to practicing in this area. So that's like the story of my report that I submitted for this one. Thank you.
Okay. Thank you very much, Rebecca. Thank you for touching intellectual property protection for businesses all around and also talking about branding. So I was talking to Mr. Folarin yesterday and he was trying to say that when you go into the regular markets that we have here in Nigeria, it's hard to distinguish one market woman's shop from the other one because they just have like their products poured out in front of their shops, and some have names and some don't have names. They just call them mama this, mama that, and all that. So beyond sitting in a class to talk about trademark, branding, copyright, etc., we also have to find a way to bring it down to the simplest form where anyone can understand it. So I'll be asking Mr. Marx to make the first comment on this presentation because he has another program today. Mr. Marx is the founder of Everlaw Associates and he's a very special person to us because he was consistent throughout the first session, and we're excited to have him here today. You're welcome, sir.
Yeah, Juliana, thank you very much. It's a pleasure and, of course, a huge privilege to be back on the program this second season. And, of course, I must give a lot of respect to my very senior colleague, Mrs. Nwokocha, who is also on this call. And it's, I think the first point I would make is for the mentees to know that it's, you are really in a privileged position, and I would encourage you to really use this position very well. Even for me, who is relatively, or who claims to be a mentor, I mean, having someone like Ms. Nwokocha in the same room is a huge privilege. So please ensure you tap all you can from her, because I mean, with someone like her, you are sure you are related to someone who is at the highest heights possible. I mean, if we're judging this, by hierarchy of courts, I mean, you're talking to like a Supreme Court justice, so far as the IP world is concerned, when you have someone like Ms. Nwokocha, available to you. So please, I'd encourage you, ensure you use this opportunity. And my apologies, unfortunately, I'm speaking at the African Arbitration Association conference, starts by 5 p.m. So I won't be able to stay with you till the end of this class. So I just want to make general remarks. I won't particularly speak on the presentation just made by Rebecca, even though it was an excellent presentation. I'll just say a few things which are my general thoughts about how I believe you can make the most and benefit the most out of this mentorship program. For me as a person, like I said, I mean, Juliana thinks I'm a mentor in this program, but I believe I've benefited even as much as any of the mentees have, because I've also learned a lot. And for me, one of the things that strikes me about this engagement, this mentorship program, and the style that Juliana uses, which I would encourage you to really adopt, is breaking down IP in very simplistic ways. I mean, I've seen the presentation by Rebecca, just a few minutes presentation, but then it was, for me, deep enough to really touch the essentials, while at the same time, it was easy enough to follow and understand. The challenge you have had in the IP world more often than not is that businesses usually don't understand IP. IP for them is kind of high sounding. So a lot of times when we IP people speak, we speak over their heads. So having a program of this that helps you break down IP concepts to, their elementary stages where anybody can pick and understand them, and particularly because your assignments are always situated within the context of industries. What it does for you is to help you really see IP in action, IP really in the way it ought to be. So I just encourage you, as you adopt this style, please continue with this style, and we'll see a revolution in Nigerian IP space, and I mean the African IP space, when we have IP professionals who are able to communicate the complexities of IP with a lot of simplicity, a lot of directness, and a lot of concision as well. So I just encourage you to continue with this. And of course, next week I'm going to be here full all through the session, so I'm going to take my time and make comments. I'll still look through your submissions for this week. If I have any comments and observations, I'll try to raise them through Juliana, so it gets back to you as well. So thank you all very much, and apologies, I'll soon have to run off. Thank you, Juliana, back to you.
Max, before you go, I just thank you for your very kind words. I was actually wondering who you're describing, because that didn't sound like you. But thank you so much. And I also want you to know that I will hold forth while you're gone, so don't worry.
Thank you so much, ma'am.
All right.
Thank you so much, ma'am.
Okay, bye.
Yes, ma'am.
Thank you. Okay. So, Mr. Folarin, okay, I think I sent you an unmuting. Okay, please unmute yourself. Yes, sir. Okay, so thank you very much, Ma. Mrs. Uche Nwokocha is a partner in one of the leading IP firms in Nigeria and Africa, Aluko and Oyebode. And we are excited to have her here because it's an honor and we do not take it for granted. She would be commenting on your presentation now, Rebecca. You're welcome, Ma. Thank you so much.
Thank you. Thank you so much, Rebecca, for a very well thought out presentation. Well done. I'm just gonna highlight a few points because like we were taught in law school, a lawyer does not need to know everything, but at least we have to find the law. So we're learning from each other. So today is gonna be interactive, and then we'll just brainstorm and make sure we get to the roots. So you started by discussing the trademark registration with the trademark registry as against the company names registration with CAC. So you rightly pointed there are two different things. And oftentimes, businesses, they do not know the difference. All they know is a business name. Like, you know, the Coca-Cola company happened to use their trademark name as a business name. So it's the Coca-Cola company and their iconic brand is Coca-Cola, the one that we drink. So there's a mix up here and there. So for them, if they register their trademark as a trademark, it's okay, they're covered. You can do business anywhere. You don't have to be a company set up in Nigeria to own a trademark. You can come from overseas and register. What is important is the registration, and it's first to file. So if you're the first to file, then you enjoy protection under Section 5 and so many other sections that will apply in the Trademarks Act. Whereas for a company name, if for instance, I want to register a name, JCC, as my business name, and then I have a trademark called ICC, I still need to register the trademark, because if I don't register the trademark and somebody starts using ICC, even though I have JCC as my company name, I cannot object to the registration of somebody who is coming after me, unless if it's a well-known mark. That's where branding will come in. With branding, it's a higher step than normal trademark. You are, apart from having a logo, if you just have a logo called JCC, it's nothing. But over time, you spend money in making that brand well-known. For instance, like Rolex, like the Coca-Cola, some of these companies are over 100 years. So over time, they've built their reputation and goodwill. Or take iPhone, for instance, Apple. And Apple is the apple we eat as a fruit. But then it's allowed to register Apple as a trademark because it has given it secondary meaning. Apple now can, and then it's so unique. And one of the requirements for you to claim protection under the Trademarks Act is that it has to be distinctive. So the apple is distinctive because it's no longer a fruit. They've taken it a step further and they have expanded it, they've invested in it, and it's now well known. So with that, brand is simply what people say about you when you're not there, which means anybody, you know that Coca-Cola is good. Even when they are not there to listen to you, you're busy talking about them, talking about Rolex, talking about Apple, iPhones, and iPad, and what have you. Okay, even coming nearer home, look at the telecommunications. You look at Glo, look at MTN. Talk about banks, everybody say, oh, Stanbic IBC. They invest, or GTB, or Access Bank. They are just not one bank that opened in a community area. But let's be clear, the bank that opened in a community area can over time become so well known. So it's what you invest, the money you put, that will make your brand to be well known. So, and then for the service marks, where the communication industry and banks will come in. Before now, service marks were not recognized in Nigeria because, as you know, our laws are so archaic, so it's only trademark. But now, with the minister some years back, over 8 years ago, now passed a regulation allowing service marks. That's why the banks are registering their slogan. You talk about Access Bank and the trainings that they do and the awards. All these are service marks. So now you mentioned also e-commerce. E-commerce is the order of the day now because of the pandemic and everybody's at home. So we're no longer like going to the shops to buy things. I can stay and order Coca-Cola stuff or Apple food to be delivered to my house. That speaks volume because the fact that we're in e-commerce, it must be a good brand. I trusted that what Apple would deliver will meet my expectation or even exceed it. Otherwise, why will I order a brand that is not well known? I might order crayfish and they bring tomatoes to me. So it's really very important that companies invest on branding, because whatever you put out there, the public perceives it the way you put it. You're not there to defend it and say, okay, that it has hyphen and it has no comma. So it's very, very important that brand owners really invest on promoting their brands in e-commerce as we have today. That's my my comments on Rebecca. Rebecca, well done. Thank you so much.
Thank you very much, Ma. Thank you for such wise insights into business protection and branding also, and the way you're able to relate it with everyday businesses that we see like banks, etc. Thank you, Ma. We'll be calling on Mr. Folarin. He's the past MBA president or chairman for the Abuja branch and also the founder of Truman Rockwood Solicitors. He's a mentor and he was here also for the first session that we had. That's the first quarter, and he's also here. We are very grateful, sir, for your commitment to ensuring that the new mentees learn about IP. Thank you, sir.
Thank you very much, Juliana. Is my mic? I'm testing a
Yes.
new mic. Okay, it's audible. Okay.
Yes.
I should apologize for coming in, joining a few minutes late. I am testing a new mic, so you should forgive me for that. But I should once again say well done, fantastic work. Congratulations on this new stream or this new season, according to Marx, season 2, episode 1. Fantastic stuff. Well done. I came in a little late, so I didn't catch the bulk of Rebecca's presentation. So I'm not sure I should actually speak to it, but at least I caught the last bit, and I caught your comment on the conversation around what IP, how ordinary businesses, in Nigeria respond to IP, taking a cue from the conversation we had yesterday about the orange market, and how if you start talking IP to these people, it will seem as if you're either there to scam them, or to deceive them or something. So I think there's a huge disconnect, but thank God for innovations like this. And I should also I would join Marx to hail Miss Nwokocha. She's a very senior colleague, one of the pioneers of IP in Nigeria. I'm not sure I don't think she knows me, but some of us are big fans from far, far, far away.
You can't be too sure. Perhaps I do. So don't just don't make it.
I know she can't know me. No, I don't think she knows me.
But at least we are meeting today, so I know
yes,
your face is good. Yes, that's why forums like this are good.
Are good, yes.
Okay.
Pleased to meet you, Ma. So, I think with someone like her, she's done a lot of work, phenomenal work in the IP space in Nigeria on international level. So I would say your interns, are actually blessed to have her, on this conversation and as part of this session. So with that, I would say thank you very much. I'm sorry, Rebecca, I actually read through your presentation. I think Juliana sent it to me much earlier, but because I didn't join, let me not take us back too far. Thank you, Juliana.
Thank you very much, sir. Quickly, we'll be moving to Adetola. I'll be unmuting you now so that you can make your presentation. If you have your slides, you can just share it. But if you're not able to share, then you can just present. Thank you, Adetola. Okay.
Okay. Good evening. Good evening. So, my name is Adetola Jislemi. I'm a Part 3 law student of Obafemi Awolowo University. Okay. Moving on to my presentation, I have the topic here: blockchain and intellectual property. Blockchain is a decentralized ledger of transactions that is duplicated and distributed through the blockchain's entire network of computer systems. Now, before I move on, I wrote this article or this piece so I can show law students or lawyers themselves that there's a way you can leverage blockchain technology to affect intellectual property. Now, and I also gave use cases of blockchain in intellectual property. The first one, we have non-fungible tokens, also known as NFTs. These are critical blockchain-based intellectual property innovations. They can be used on a blockchain to represent unique properties, and also innovators or developers can put their NFTs or their piece of work on the blockchain technology, resulting in undeniable proof of ownership. Now, okay, can you see hear me?
Yes, very well.
Okay. Okay, my network went for a while. So that's the first use case of blockchain in intellectual property. Now, the second one, IP lawyers can also use the blockchain to provide proof of first use, creation, and rights management, reducing the number of cases of intellectual property infringement. A lawyer can use the blockchain to set up the terms of sale and license of an IP for his or her clients. And since the blockchain is a secure and transparent technology, it better protects the client's IP rights. Such companies that have done this are TinEye, Binded, JIIPCC, and Media Chain. Now, the third use case of blockchain in intellectual property, innovators and content creators may also put their copyright on a smart contract, which will pay out if certain conditions are met. As we know, smart contract is a blockchain-based computer program that runs automatically whenever a predetermined condition is met. So when innovators or content creators put their copyright on a smart contract, once payment is made, it can serve. The blockchain technology can serve as an IP marketplace, and such companies are Patentico and IPWE. The fourth one, we have during the life cycle of digital assets such as patents, copyright, and publications, there is a need for a technology that allows different copies of digital assets to be linked together. So when you upgrade your technology over and over and over again, instead of having it scattered all over the place, the blockchain technology can be used to merge all those copies or versions together. And one example of such company that has done such is the Bernstein IP. And I think that's all for my presentation. So.
Thank you very much, Adetola. This is a new topic, not just to myself, but to like a lot of people. So when I saw your presentation, I was like, wow, blockchain, this is really good. And I'm surprised to even know that you're a 300 level student. So I'm excited that you're actually trying to read and know about these unique new emerging areas. So I'll just call on Mrs. Uche to comment on your presentation. You're welcome.
Thank you, Juliana. Thank you so much. I'm going to join you in thanking Adiola so much. She did fantastic work, and I learned, apart from reading about blockchain, when I learned that CBN is not a fan, and then my office, a department in my office wrote on it an article. And then my comment is always that Nigeria, we can't shut ourselves from innovation. You need to be part of the international fair so that you can compete well. So we can't be left behind, because if you don't innovate, you're left behind, you simply die. So I'm quite impressed that, like you said, at 200 level, she could do that. But that speaks on the fact that this is the digital age. I mean, it's their stuff. So, and people should, if you see what is happening now, even with e-commerce, I think COVID-19 kind of revealed what is wrong with old businesses, because some law firms could not really meet up because they didn't have IT in place, to prepare with a sudden change like this. So change is good. We've learned that we need to keep changing and keep moving with the rest of the world. I like that she mentioned that it can be used as proof until the counterfeiters probably find a way around it. But for now, it's very good that you can use it to prove first priority that you're the owner. And then I learned in one of the International Trademark Association publication that blockchain can be used to fight fakes. you know, so which is good. I mean, if we can do that, that's a huge achievement. Those are the uses you can put blockchain to. And also, nations, okay, innovation can be used to grow a nation's economy. So, I mean, if you're not competing with the rest of the world, then your economy will simply suffer. And finally, then the nation can compete in the international firm with everybody. So it's a new area, and it's good that we'll explore in it. And then I urge Adeola to do some more research, follow what is happening in the international forum, and see, because what we do, you're even lucky, some of you, that you studied intellectual property in school. I did not. They never offered intellectual property when I went to school. So it was when I left school, the first law firm that I worked, Buck & Co., it's like a British law firm, and then intellectual property, I didn't even know anything. I was going to court doing other things, but I will always know to go to the clerk, because it's the clerks that will do it for the partners, you know, to look at, oh, what is logo? What is device? What is this? So I started gaining interest. And from that on, I never looked back. It's a very interesting aspect of law practice because it keeps evolving. Look at blockchain has just come. And there's so many, there's trade secrets, DARA, IP is so wide that it's unbelievable. It's just that we do not know. But Nigeria is trying, at least the companies in Nigeria, everybody is now all about brand. And when you buy a Nike shoe, you believe that it's better than Adidas, because even Nike said it. He said at one time, they said, either kill Adidas. There was some slogan that they used that was like, you know, and Nike will tell you, just do it. So these are things that are encouraging when you have all these slogans or taglines, like the one you have for American Express that will tell you never leave home without American Express. So these are Nigerians have started. The banks will just come up with taglines, and then that keeps them in your memory because you now know about them, then you want to be part of a good brand. So thank you so much, Adeola, for that presentation.
Thank you very much, Ma. Thank you so much. So, Tola, I think something else that we're going to do here because of this your presentation, we would try to find a lawyer, maybe someone in Nigeria or a foreign lawyer that would come and take a session on this. So when it will be happening, I would let everyone know so that you can read ahead and prepare your questions for the lawyer. So I'll be calling on Mr. Folarin.
Oh, before you go, the department in my office that have been following up, excuse me, I can link you guys with the lawyer and then take it from there because she's really vast. And then when we had a teleconference with lawyers from UK and South Africa, they read her articles online and they were really impressed. So let's start at home and then if we look beyond, then we can do that.
Thank you very much, ma'am. Really grateful. Thank you, ma'am. So, Mr. Folarin, over to you.
I should say thank you, ma'am. I think in addition to, I don't know what that is. Okay, let me put it down. In addition to, I should also mention that Senator Ihenye is also an IP person. He's the chairman, or is it the president, national president of the, I think, blockchain something association in Nigeria. So he's someone that he's been preaching blockchain for about 5 years or 6 years now, even before people started talking about, you know, blockchain, or before crypto became, you know, as mainstream as it is. So he's a fantastic resource on this topic, in addition to, of course, the vast resources of Aluko and everybody. But I must say this topic is very interesting. You know, you and I had a quick chat about it the other day. NFTs, in fact, NFTs are the rave of the moment when you're talking about, you know, new technology or blockchain. And in fact, particularly IP, because NFTs are a particular type of IP. But I like the way your article is, or your write-up is structured in such a way you're looking at how IP lawyers can use blockchain. And I think a lot of the mainstream conversation, at least over the past 3 or 4 years, has been how blockchain can be used to achieve X. And that's why when we're talking about crypto, crypto is built on blockchain technology, and it provides all the advantages, or it gets all the advantages of blockchain technology. So I find that it's an interesting conversation when you're talking about how lawyers can leverage off of blockchain technology. Smart contracts is fantastic, but for me, my main area of interest, I think, in this conversation is, has to do with NFTs, that's non-fungible tokens, and the impacts that non-fungible tokens are having, or the way they are, as a concept, the way it's disrupting the IP space, and even, the crypto space as well. I think these are conversations that we should start having. When Juliana mentioned that somebody was writing about blockchain, the first thing I said was, oh, NFTs, and she said, oh, that's, you had mentioned we're doing something on NFTs, and I said, oh, that's fantastic. As Ms. Nwokocha said, what's it called? There's a shift towards, cyberspace. If you look at Nigeria's internet penetration as at 2019 was about 42%. 2020, I think roughly about 43 or so. We're now up to 45% internet penetration, and we know that data prices are a little high. But if you look at volume of crypto transactions, and this is across the blockchain space, Nigeria ranks number 3 in the world. Nigeria currently ranks number 3 in the world, in terms of volume of crypto transactions. So that says a lot. You can argue that maybe some of the transactions are money laundering or whatever, but in terms of volume, we actually control a huge volume. I partnered with a company that did a survey late last year, early this year, on e-commerce transactions, and we found that a very large number of, some interesting, we've revealed some interesting findings on, in the e-commerce space, especially around dispute resolution and use of IP. And you find, there are a lot of e-commerce service providers want to differentiate themselves, from the other person. And many times, Juliana, she's an Instagram celebrity. You find people on, you're laughing, it's true. You find people on Instagram, creating brands and, creating catchphrases and slogans and bylines and taglines and so on and so forth. But you rarely find situations where these people actually take that necessary step towards, registration until something happens. Yeah. And so, for example, I've had to have conversations with trademark owners. Somebody does, I know Instagram, I like the concept of name similarity, in the abstract, because when talking about name similarity, if you look at, of course, the Trademarks Act deals with, there's a standard, if you look at Section 9 of the Trademarks Act, relating to distinctiveness or, distinctiveness, the standard as to distinctiveness. If you look at Section 30, Section 2930 of CAMA, there's a different standard, as to distinctiveness. But both sections still talk about names. If you look at the INEC, the Electoral Act, sorry, you will find there are also requirements as to name similarity. So when talking about name similarity, it depends on the rules of different platforms. And with the rise of social media, it's possible to have, very similar or even the same username, depending on what platform, you're on, to have very similar usernames or similar account names, different usernames, so it's easy for passing out to occur. It's easy for brand names to be hijacked, to be diluted, and so on and so forth, because the threshold for name similarity is very low, especially on social media platforms. So I think these are important conversations that we should have, because I don't think the world has ever experienced this level of access at any point in time in the world. We've not had it this way this is new to everybody, as Juliana said, and I think it's high time we started to have some of these conversations. I had a chat with a potential client, something fresh juices for you or something like that. And then there was someone with the username juices fresh for you, something like that. In those scenarios, it's important to reach out to these people, to reach out to these businesses. And I think at the moment, there are over, Instagram has over 1 billion. I'm sure it's probably much more than that now. But I know that there are hundreds of millions of Nigerian accounts, on Instagram, for example, as an example. So in terms of how does IP feature, or how can we, or what are the relationships between blockchain and intellectual property? I think NFTs, new tech are the way to go. And just a quick word, I like the fact that you also referenced NFTs. There's a suspicion, I should also mention that there are reservations that NFTs might just be a bubble as well. There are also concerns that crypto itself may be some kind of bubble, and I read recently, I think about 2 days ago, that Jack Dorsey's first tweet was sold. The original screenshot of Jack Dorsey's first tweet was sold for about $65 million. Now, what blockchain does is blockchain allows you can look at the technology allows you to look at, to confirm that this particular file, you can look at the hash of the file. So that's the zeros and the one, the unique sequences of zeros and ones, that make up, it's not just the user interface, what you see, but you can look at the bytes in that file to determine whether this is the original file or just a copy. And blockchain, which, provides to the nth degree, a very minute or a very extensive level of verification. The fact that you can actually verify that, okay, this was Jack Dorsey's first tweet, this was the first copy of Jack Dorsey's first tweet, allows people, the owners of these NFTs, to sell them or to auction them or to market them, for outrageous sums. So blockchain does provide an avenue for authentication. Yes, that's the word I was looking for.
Yeah.
And talking about authentication, if you look at this section 84 of the Evidence Act, it talks about authentication. I feel that that section has to do with formalities of authentication. But when talking about authentication from a digital perspective or from a data analysis perspective, it's more of a technical issue, because what you're looking at is the hash of the file to determine whether this is the actual file or it's a copy. Every digital copy, has a little extra. There's a +1 or a 0. There's an extra byte that is added when you create a digital copy, which we cannot see. When you right-click copy and right-click paste, there's an extra byte, just very minute. You don't see it in the size, but there's something that registers that shows that this was a copy of something else. So I think it's a good idea to welcome more conversations around how we can use blockchain in the IP space. So well done, Tola. Thank you.
And then Folarin, I was just gonna add to what Folarin has said, that at least for the multi-level security has made it tough for somebody. And again, if you're not the original person, nobody can make amendments. So you see, with all those, so that's what makes it very attractive. So it's not easy for somebody to copy or fake it. They've really made it so difficult. That's why blockchain is good. Thank you.
Thank you very much, Ma. I'm very happy about the kind of topics that have been submitted for this first week, because by the time you submit about trademark and you're done with this class, you would have learned about several other topics, and that's why we are here. So I'll be calling on Brandon to quickly present his own paper. Hi, Brandon.
Hello, Juliana.
Hi, Brandon.
Can you guys hear me?
Yes, we can hear you. Please, kindly introduce yourself and then go to your paper.
Yes, my name is Brandon Omondi. I'm a Kenyan lawyer based in Nairobi. And today I'll be making a presentation on the cross-border enforcement of image rights. So one of the most important things that I would like to begin with is the fact that intellectual property lawyers generally, for the longest time now, have held the opinion that that IP rights are generally territorial in nature. However, in the modern age of technological advancement, this argument, I think it dances precariously on the edge of extinction because the rapid state with which technology has made the world to go, it's very easy for people to share images and pictures and any other thing that touches on the image of a person. So for those of you that follow football, there was a case that happened in 2020, late last year, where Gareth Bale, I don't know if any of you guys know Gareth Bale and Zlatan Ibrahimovic. So what happened was that Gareth Bale and Zlatan had a problem with the EA Sports and FIFA Pro because the two institutions used their image rights without their permission in the popular game known as FIFA. I'm sure most of you know the game. So this is just one example of the disputes that arise about image rights, about international image rights. So as I've mentioned, we are living in an age of technological advancement. And in such a state, image rights and other rights, other intellectual property rights, they transcend geographical borders and boundaries. Therefore, on this ground alone, it is very necessary for us to start having conversations around the establishment of an international regime or a cross-border regime for the protection of image rights. So when I was doing my research on this topic, I have developed great interest in this topic, and I've started writing an article about it. So basically, I don't know, one thing I've noticed in Kenya, not only in Kenya, but even in Europe and some sections of America, is that IP rights are very esoteric. That is, not so many people appreciate intellectual property law generally. I don't know about the position in Nigeria, but I usually feel like African countries take IP law more seriously than many other countries. I think the only countries in Europe that compete with African countries in terms of the seriousness on intellectual property, especially in the 21st century, Germany, France, and perhaps Spain and Italy. But the rest, they have feeble regimes of protection of IP rights. So when you talk about cross-border image rights, they usually arise in two ways. The first way in which they arise is the contractual sense. When a contract encompasses, or when a contract exhibits foreign elements. For example, when the parties to a contract belong to different states, or when the subject matter of a contract relates to more than one country, or if the parties decide that in case of any dispute regarding the contract, such a dispute will be had and determined in a different state. Now you see that such a contract embodies foreign elements. And it is these foreign elements that necessitate a regime for international or cross-border enforcement of image rights. The second sense in which cross-border image rights arise is in the context of tort law. So in tort law, there are different types of principles that apply. The first one is known as the double actionability. This principle stipulates that for a person to have a remedy in one country, the course of action must be acknowledged or protected in the other country. So if a person's course of action is not acknowledged in another country, then such a person would not have any remedy in that country. So it is based on these grounds that I propose that we establish a general and international system where image rights can be protected. So I think that is the gist of my presentation. I don't know if any person has a question.
Okay. Thank you very much, Brandon. I really like the angle that you took also in your presentation. And I would just like to add that, yes, it's actually true that the world has moved from physical to virtual mostly, and most of the infringements that occur mostly online because people move images. And if you look at most countries, they do not have like specific laws for this image right. So some just come under common law or privacy, right to privacy. But if something is infringed online and it's international, then you have to be thinking of jurisdiction and all that. But there are also ways to take all those things down and all that. But most if they are trying to go beyond just reporting it to the online provider and trying to get like damages for it, then they would need to go to a court. And I think treaties are usually available for things like this, but I'm not sure if any treaty addresses this specifically. But even when treaties come, countries have to sign up to it, and then there are some countries that have to ratify it, etc. So it's an interesting topic, and I think it's something that countries should look into. So let's welcome Mrs. Uche. You're welcome, ma. Please help us to address this topic.
Well, this is really a tough one because I was wondering why the last speaker said that that almost like it's a myth to say that IP laws are territorial, but they are indeed territorial, because that's why we're having issues with online. Because if the online businesses are within jurisdiction, like you said, then it would be easier to tackle them and go to court and find where they are, serve them with notices. But if the online is very, very difficult, except that people who are enforcing online illegal practices are now developing ways to have like multi-level checks, where, for instance, somebody wants to sell something on eBay or Amazon. You ask them, they say they do not know that somebody just used their marketplace to sell. But then we'll go further and say, but they paid you or you paid them. So let's look at the payment channel and see. That way we'll get to the bank. The bank must have the address of the person you paid to, stuff like that. So I guess as the online is evolving, then lawmakers are beginning to look at ways to combat all of those issues that they didn't think of when we were doing all the manual because if, for instance, you registered a trademark in Kenya You can't come and claim protection in Nigeria if you didn't register in Nigeria. That's why it's territorial. The same thing happens with copyright. What happens with patents? And you need to prove that you register within jurisdiction. It's okay for you to say, okay, it's well known, but you cannot claim right against a third party, an innocent third party that goes to register before you. Unless, of course, if you can establish that the person registered in bad faith, like somebody knew about a singer, maybe Beyonce. Everyone knows, even though Beyonce is not here in Nigeria, but we all know about her. And then somebody goes to register Beyonce, then that way, it can be established that you registered in bad faith, that you are aware of the existence of that well-known trademark. So I still think that the reason why some of these treaties that you mentioned are not really very strong, they're almost like a toothless bulldog, is because they have to be domesticated. Even the Madrid Protocol, the Patent Cooperation Treaty, the Paris Convention, all of those, if you don't domesticate it with our laws, how would the trademark registry officials know what you're talking about? You need to have it. You need to have a law. You can't just like in normal practice, you can't go to court and charge somebody if you don't have an offense and the law that made it an offense. So I still believe that, and again, there are also some other domestic perception. Here we have Muslims, we have born-again Christians. There was a time I was trying to register something on NAFDAC, and NAFDAC says to me, you can't register, the person is wearing bikinis, wine. Whereas in Brazil and in the Western world is okay, but in Nigeria, no. They say that it's offensive to Muslims or to Christians that work. No, that I need to cover it. So we have to cover the design and put clothing, just to cover the woman, because those are the things you look at jurisdictions. You need to abide by the laws of the jurisdiction where you want to do business. And also there are some negative connotations. Sometimes you do searches or a foreigner wants to register trademark in Nigeria. Do you think that if they have a name, Magu, excuse my language, or some other things, I can tell them to register. If they register, nobody will touch it. It's taboo. You understand? So those are the things you look at. You have to change the language. You need to change it to meet the jurisdictional expectation and perception of the people. So that's my 2 coins. Thank you.
Thank you very much, Ma, for that perspective. We'll be calling Mr. Folarin. Mr. Folarin Aluko.
Thank you very much, Juliana. Yeah, I think Brandon, that was a nice one. The image rights is an interesting area, especially because we find that it has this allure and appeal, to many people, especially people if you're in a country that has a very strong celebrity culture. So a country that is that places a high value on like popular culture, we find that there's a huge emphasis on image rights. But I would also agree with Mr. Nwokocha that let me just quickly take a tangent now. So I agree with her that yes, of course, IP is territorial, and for good reason. She has listed all the reasons why it should be and why it is territorial, because you don't make laws. The laws have to fit or speak to the people in that particular jurisdiction. But taking that a little further, because technology has shrunk it has reduced or shortened the distances between people. And especially when you now look at situations where people use the likeness or the images of popular individuals. Now, you referenced one of the eSports cases. I've had the opportunity to follow some of those cases. The representation of popular players, in sports. Usually, there's some kind of license or release that is signed by the players for their likeness to be used, in popular video games. And that's a big industry, because the gaming industry is a multi-billion-dollar industry. And I think that's one of the reasons why you find image rights very strong in that area. You find it strong in gaming. You find it very strong also in music. I think there was last 2 or 3 years or so, I'm not sure. I think Rihanna tried to file an action to enforce, quote unquote, her image rights. But you also find a situation where, as Juliana has said, there are not many countries that have actual years ago. It was probably the only country or the only sole jurisdiction where you had image rights at a national level or at a federal level. States recognize it as a tort, as you stated. So it might be interesting, to talk about having it's an interesting thought to talk about having a cross-border or an international treaty on image rights when we don't even have local legislation, on image rights. So it will be interesting to see how it plays out. But I do agree that there is some value to be had in that conversation, especially I'm speaking as a Nigerian now at our own local level, here in Nigeria, because you walk into a barbering salon, for example, and they will ask you, do you want 50 Cent or you want Two-Face or you want this one or that one, or somebody says they're organizing a program and you see on the flyer pictures of popular celebrities as though these celebrities will be there, even though there might not be any intention to invite them. But I think that there is a lot of, at least in Nigeria anyway, there's some sense to having those conversations, because I was watching or I read on Twitter recently, one of these celebrities who he put some persons on blast, for using his picture on a flyer without inviting him, for the program. So there's a conversation to be had about how do you ensure that the pictures or the images of these people are protected, of certain people, of all persons actually, are protected from commercial exploitation. There was a case, it was filed as a copyright case in Nigeria about 3 years ago. It was a Wema Bank case. A federal high court sitting in Lagos, Nigeria, awarded about, was it 10 million naira, it was filed as a copyright infringement, a copyright infringement case. The federal high court awarded about 10 million naira to a model, a lady whose picture was used by Wema Bank about 3 years ago or so, 2018, about 2018, 2019. But unfortunately, it was filed as a copyright infringement case and not necessarily as an image rights case. But from the conversations around image rights that I've seen, I think from just common sense, it shouldn't, there's the flip side. The objective should be to protect the person from the unlawful commercial exploitation, and to also protect the public, from being misled and deceived, as opposed to, okay, my picture was used, so give me 100 billion naira, as opposed to turning it into a cash cow. Because what we're likely to see will be a deluge, like the floodgates of litigation and contentious applications might be opened, for if and when, or if image rights are legislated upon. I think in Guernsey, what they did is they created a registry. So in order to file an action for infringement, that image or the person's likeness or whatever would have to have been registered at the registry. So it kind of creates an entirely new set of procedures and rights and systems, if you may, So you have a registrar who oversees the registry, and then just like trademarks or like, patents, you register your image, and then in the event that that image is infringed upon, you can then bring an action, and so on and so forth. So I think it's an interesting conversation. My chief concern, like I said again, is that there's a likelihood that it may turn into it may be weaponized and may be used more as a sword than as a shield. And then, as Ms. Nwokocha said, how do you enforce cross-border use of your likeness or image? How does 50 Cent stop the barber in Ojuelegba in Lagos State, from putting his 50 Cent, like, this is 50 Cent barbing salon? How do you stop that? How do you protect? How does he enforce those rights? Or if it were someone in Iran organizing a concert and using Beyonce's picture, so it does give cause for some conversation. I think, yeah. So it's a conversation that we should have, and I would say, well done for raising it in this way, Brandon. Thank you.
Okay, thank you very much, sir, for the insights that you gave. So I'll be calling on Dawn to take her presentation. Hi, Dawn. Please introduce yourself and just take the presentation. Thank you. Hi, Dawn, are you here? Okay, she has unmuted herself. Yes, I can hear you. So if you're able to share your slides, that would be nice. But if you can't share your slides, just introduce yourself and start your presentation. Thank you.
All right, my name is Dawn Osioma. I was called to bar in November 2019. I'm really glad to be here today, and thank you for selecting me as one of the participants of this program.
Thank you.
My presentation is on the impact of intellectual property protection on startups. I chose that topic because I have an interest in startups, businesses in general. So, and how they can protect their selves and protect their intellectual properties. So I talked about the fact that during the early stages of a business, most entrepreneurs or most business owners, they do not factor in IP, protecting their IP. They might think about location for their business, funding, and a whole lot of other stuff, but they do not consider protecting their IP. So down the line, when an issue arises, it becomes they become reactive rather than proactive. So I said that some of the stuff that things that a startup should consider in protecting its IP is, first and foremost, is that it needs to engage an intellectual property attorney, because not everyone has a grasp of what intellectual property is as it pertains to businesses and all. And then the first thing they need to look at is what kind of intellectual property do they have? Is it the trademark they want to register? Is it copyright? Is it patent? So they need to factor in this. And then they need to also check if that intellectual property is infringing on someone else's intellectual property. If that IP is already existing, then that would be something to look at also. It means that they cannot register it. Then how can it protect its IP? For example, copyright is automatic. So you need all this knowledge as a business owner. And then how can the intellectual property, protecting their intellectual property, support the company's commercial growth? And the effect of all of this is that it helps a business gain advantage over its competitors. because once they've registered an IP or put that into consideration, they would gain this competitive advantage. There was a recent case that came up between Fearless and Predator Drink, and they were about, Fearless said they registered their name first and then their logo and all. And so the effect of all of this is, if they had an attorney, then they would have considered, okay, is there somebody else with this logo? Has the person registered it? And if the person has registered it, what is the effect it's going to have on us down the line? So Predator would consider, okay, if somebody already has this, this logo, it means that there would be a suit that would arise so and so time. And then what effect does it have on consumers? Are people going to be able to distinguish between these two products? Because when I looked at it, I saw, okay, there was a bit of similarity between them. And so another thing is that it helps them earn revenue. So when they protect their IP, they are able to license it to people. And it also helps them project a good image to investors, because when investors come into a company, part of what they look out for is your IP protected? So they would know what they are getting into. And so that's it. And then I also looked at issues that should be resolved between employers and then employees, independent contractors. So they should also check and settle the fact that whichever or whatever product is being produced by an employee or an independent contractor is going to be licensed to the company or to the contractor. So when issues arise in future, they would know how to solve it. And also some of the ways that a startup can protect its IP is first by developing a strategy for protection, registering it, dating their works for copyright, for example. So if you have a date, time, and all of that, even if you've not registered, it also helps you later on. And then signing non-disclosure agreements, doing an IP auditing and all. So in conclusion, it's better, although startups can pursue or go against people that infringe on their IP under unfair competition, but it's always advisable for them to register. So that's all the effects IP registration has on startup. Thank you.
Thank you very much, Dawn. I feel it's extremely important because with the issues that we're having now, like with COVID that came and with the economic issue where Nigeria is, you find that many people are starting their businesses. So we also run a firm here, and in like months, like you realize that a lot of people are starting their business. And when you ask, they just feel that they've already registered with CAC and so they are fine. But registering your IP is beyond registering with CAC. It goes far beyond that. So you have the trademarks, copyright, patents, etc., design, depending on how your business is structured. So I'll be calling on Mrs. Uche to comment on your presentation. Thank you.
Thank you, Dawn. Thank you so much. Well thought out and well prepared presentation. First, might I just say that the issue of license will not arise between an employer and employee, because any work done by an employee whilst in the employ of a business owner belong to the employer, except there's an agreement to the contrary. So if you don't want the employer to have the right to whatever work that you created, you must stick it, you must put it in an agreement. So it's none. Otherwise, the general rule is that whatever that you created during your employment years belong to the employer because you use their resources. That is the idea behind it, unless if you specifically said no. then that agreement will guide the ownership going forward. And in some cases, some employers will even put some agreement in place, like restraint of trade, which some people also frown at. Some of them will tell you that a year or 2 years after leaving their employ, you cannot work for their competitor, or you cannot use what you created. So I think the wisdom is for you to know what you're doing, put it in an agreement for when you go to court, so it will be written, because we all know as lawyers that you can never use an oral agreement to vary a written one. So it's always good to really put it in writing. And then as for startups, I know that when you're starting a company, you're so excited, taking care of everything, the decks, the books, the everything, inventories. Nobody is talking of intellectual property. Yet intellectual property is the most valued assets a company or a startup could own. So it's very important, like you rightly mentioned, Don, that they must look at registering their trademark even as a young startup, because as you're starting business, you're not well known, you're just struggling. But over time, you might have developed a business that has a vacuum in the market and it's not available, and then people will come. We've read stories of startups being acquired by big companies and paying them huge sum. So it's very important that you register it, because for the company, like you rightly said, that anybody that, if you even want to borrow money from the bank, they look at what you have, not just that you say you have IP, but is it protected? Because nobody wants to buy a lawsuit. So it's very important that you put all those things in place before you even venture, because if you don't, there are people that are looking, they could go and file it after you've come public. So before you actually come publicly, it's best to iron out all your IP rights and register them and keep them under close lock and key so that nobody attempts to steal it. So IP is key for a startup, even though most of them, because you're a startup, you don't have money. But I will advise that you invest on your intellectual property and keep it safe, because that is the way, that's what will give you value. If the building is gutted down by fire and all the books are gone, all your equipments are gone, your intellectual property is what you have that is in your head, is your creation of the mind. The name that you built is what you have, and you can rely on that when things go down. Thank you.
Thank you very much, Ma. Thank you, Ma. I think that as legal practitioners, we also owe our clients the duty to advise them why they actually need IP, because some of these people are not knowledgeable about IP. And so if you don't advise them, they would actually think that they've actually done everything that they're supposed to do, since they registered their company with you and they explained everything. So it's your duty to then explain to them that you would, based on the objects of your company, it would be good for you to have a trademark, it would be good for you to register a patent or do a copyright, etc. So it's very important for us to also do that.
And not only that, you could even encourage them, because they don't have money. I know in my office, we have a department that is handling startup, and they really don't bill them much, except they probably pick up the expenses. So you need to encourage them so that when they become the apple of this world, they will remember you and not leave you. So it's good to also invest in them as a law practitioner and as IP law firm.
Yes, thank you very much, Ma. So Mr. Folarin is on a call, so I'll just move on to Sewese. Sewese, you can just introduce yourself, share your slides, and give your presentation, or if you don't have a slide, just introduce and go straight to your presentation. Hi, Sewese. Hi, Sewese. Okay.
Thank you, ma'am. Good evening, everyone.
Good evening.
Okay, can you hear me?
Yes, okay. We can hear you.
Thank you for the privilege to be part of this session. My name is Sewese I was called to the Nigerian bar in 2018. Okay, so I'll be presenting on trademark protection. And I was looking at the need for Nigeria to also be a signatory to the Madrid Agreement, Madrid Protocol, in order to ease business, trademark registration and all. So I was looking at, basically we've discussed on trademarks. We've said a lot about what a trademark is, the need for businesses to register their trademarks. And we also know that basically this is to prevent infringement and unauthorized use of the trademark, the license, and then also forestall possibility of passing off and all of that. And then recently I specifically wrote on this because I had someone, like a client, that wanted to do also register internationally. And then it became so difficult because it's actually an area I'm new to. So it became very difficult. And I was wondering, why is it that the Nigerian government has not looked into the numerous advantages that would gain if they accede to the Madrid Agreement? So the Madrid Agreement makes registration of trademarks easy, especially in the international space. So the effect of that registration would is such that the mark becomes effective in all contracting countries, as if it has been registered locally across those countries, as each of those countries. And then it will also remove the challenges that originally local trademark holders in Nigeria would face, that's going to maybe register this trademark internationally, and then they have to now go to register in each of the countries. So basically, I want to highlight the advantages of the Madrid system, and I listed some of them, which is single registration for all purposes without, with the possibility of adding future territories as the business grows and as other countries also accede to the agreement. Then I also mentioned the possibility to also discontinue the application of the registered mark in any jurisdiction at any time at all, even after the registration. And then I also mentioned the fact that it dispenses with the need for independent or fresh applications in different countries, as I stated earlier. So I'm looking at, especially in these times, with the modern trends, e-commerce and all of that, how the world has become, businesses have gone global and all of that, that it will be necessary and for the Nigerian government to accede to the Madrid Agreement. So recently, Pakistan was also acceded to this agreement. That was February this year. So I was just wondering why it's becoming so difficult for Nigeria to also do the same thing like her counterparts across the globe. So this is just a call for the government, entrepreneurs, and so many other persons concerned, lawyers who can also champion that call so that this is also looked into. Thank you so much.
Thank you very much, Sewise. I agree with what you're saying, because I had to also file one recently, and I remember I was talking to Mr. Marx, and he was saying that by the time he wanted to file, then use that to file and all that. So it makes the process difficult. But I feel that it's our colleagues that are still making this difficult because they like it when people have to come to register here because it puts more money in the pockets. But even though they are going through the Madrid, there is still the national fees, I think. So it still comes to us, but somehow I think there's maybe like a bureaucratic issue and all that. But thank you. Actually makes a lot of sense. And with the world being almost online now, it's important that treaties like this are looked into and signed so that we can actually get to benefit from it. So I'll be calling on Mrs. Uche to also give her comment on this. Yes, ma'am. I'm asking her to unmute now.
I'm good.
Oh, okay, ma'am.
All right, cool. Good presentation, good thoughts, good ideas, but oftentimes they have downsides. It's okay, we want to be part of Madrid Protocol. By the way, Nigeria has not signed, we haven't joined. Very few African countries have joined, I think South Africa. And when you talk to them, they tell you the problems they're experiencing. It's not that easy. I know it's, we can quickly say, okay, Nigeria does not want to join because the practitioners want to keep the work themselves. No, that's not the reason. We need to be ready. Our systems are not computerized or digitized. So there's no way you can even compete if you expected under the Madrid Protocol as well as the Patent Cooperation Treaty to file in WIPO in Switzerland, and it will be disseminated to other countries or places where you want to claim protection. For instance, maybe 3 different jurisdictions, depending on the business. You don't want to keep paying money because the cost money is huge to prepare different documents and send it to those jurisdictions and have your lawyers look at it. So it's not cheap. So you need to be sure what business you want to develop, the ones you want to give value to, and then in order to know what to do. But then that's the main reason why Nigeria has not joined, because even with what we are doing within jurisdiction, they publish a journal. It's not even online, even though our registry has gone online for the past 7 years, but I still need to buy a journal from the trademark registry and scan them and look at them manually. So how can we really now go to Madrid? So I think that's what is delaying. WIPO has been working with Nigerian registry, trying to help them with digitalization. So until they do that, we might not be able to join. That's what is delaying. And with the WIPO office, Nigeria WIPO office is gonna help a lot for us to really, for them to look at what our issues are and help us, because WIPO has been helping African countries to bring our laws, our practices in conformity with international best practices. And then I mentioned that it's also very costly. So how is it that a young startup in Nigeria, then you start going to Madrid? It's a lot of money, it's huge money that you be spending. So let's just even stay within our jurisdiction where they're doing business. If you get protection, most of them, you tell them to file in Nigeria, they say it's expensive. So how would they even file with Madrid? So it's very costly. And also for opposition purposes, if you file and somebody opposes in Nigeria, it's a bit complicated, but because we are within, you can send somebody to go to the registry to check, because the journal is not online. So I can't even do it sitting in my office in Lagos. We have an office in Abuja, and they'll have to buy the journal. I'll have to look at it with my team line by line. So the opposition, we can't even do it with the Madrid protocol. So these are causing huge problems, and it takes an awfully long time, because by the time you send it, and they send it to, maybe if you want to claim protection in South Africa or in Australia or something, and before they do it to come back, it takes years. So while the journal allows you 2 months to be able to oppose, so whatever time frame they give, I don't know, because we are not part of it. You will not meet it because you'll be busy doing other things, and then you miss the opposition. Then you lose the right you're trying to protect. So it's really a very huge thing. I think a discussion we'll keep having, and then Nigeria will join when the time is right, after we've taken care of all our systems and put our house in order. Thank you.
Thank you very much, Ma. I'm not sure if Mr. Folarin is still ready to comment, so we'll move quickly to Magdalena. Yeah. Hi, Magdalena.
Hi, Juliana. Can you hear me?
Yes, I can hear you. Can you share your screen, or you just present?
No, I'll just present.
Okay.
Yeah, the network is not very good this side of town, but I'll just present. My name is Magdalena, but I'm well known as Maggie, so you can just call me Maggie. I'm from Namibia, southern part of Africa, and I'm very honored to be part of this mentorship program, to be with people from Nigeria and Kenya, so I'm very honored.
Thank you.
Yes, I'll be talking on the 3 legs. I actually named my article 3 legs of intellectual property because I want to focus on educating the SME and startup companies within our country to really understand what is IP. Because like I said in my article, that the awareness is there on what I think WIPO and ARIPO and the IP offices within different countries are really doing a great job. However, the understanding is really lacking. Like Mr. Meg said before he left, that as IP professions or IP lawyers in this, I'm not a lawyer, but I did a master's in IP. So my focus will be mostly on IP management. Like the breakdown of IP concepts are not really understood by SMEs or creators or inventors. So the 3 legs of IP that I want to discuss, the first one is the legal aspect of IP, that SMEs and inventors or creators really need to understand that when you are creating an IP or when you have an IP, there is legal aspect. For example, if you want to register your IP in your country, you need to understand what are the requirements and what law is in place, and that IP is very territorial, that if you only registered it in Namibia, it doesn't mean that it's also registered in other countries. So SMEs really need to understand, because when I interact with certain people, you get to hear that, no, if I register it in one country, then it's a universal protection, which is not the case. And the second aspect is the technical aspect, which is that there's certain criteria that an IP needs to meet so that it can be considered as an IP. For example, with patents, that it needs to be novel, it needs to have inventive step or industrial applicability. So SMEs really need to understand this aspect, because sometimes they might waste their time creating something that is already there. Like they say in the IP profession, there's nothing new under the sun. So before they go out and register something, they need to understand that they really meet that criteria so that they cannot infringe other people's rights. And the third aspect is the commercial aspect of IP. Yes, we all want to make money from all our head-end research and everything else. But like I said, also it can be a case that you might have registered for your IP, but still you are not getting the value that you want from it. So you need to understand the commercial part. How will I market? How will I market? Do I go for licensing? Do I sell it? Or what do I do with my IP in order for me to benefit my work from it? So in conclusion, is just to say that business owners really need to understand the 3 legs to ensure that they maximize their profit from the IP that they create, and also to just get the value from what they have created. So yeah, that's all I have for today. Juliana, I can't hear you.
Okay, thank you very much, Maggie. Thank you for your presentation. It's actually a very good presentation, especially for the startup community. So I want to point out 2 things. Yes, intellectual property is territorial, but let's also look at copyright. Copyright is because it's usually at once it's put in a fixed form, it's already protected, and most countries are signatories to the Berne Convention. So when it comes to copyright, it's quite different from the rest. Then some of these startups know about IP, but they cannot afford it. So it's something about the status in life, especially in Africa. People are trying to start, and when they come to you, they're like, oh, I don't really have the funds for this. So some of them know this, but they do not have the funds to actually implement the registration processes or the maintenance of it. So I'll be calling on Mrs. Uche to take the discussion further. You're welcome.
Okay. Thank you so much to the last, Maggie. Thank you so much for that insightful presentation. You did mention, the Lego. So I will just jump the Lego aspect, because we all know that the Lego regime for IP is a trademark registry. You register for your trademark, and then if there are issues, somebody, for instance, that wants to register with CAC will always refer and look at if there was an existing trademark registration on the date that somebody applied to register the company. CAC should, there's a law, CAC will ask them to stop using the name. So priority really matters that you apply to register quickly. And then the technical aspect, you mentioned patents, yes. So if you register patent, you find out that if you register patent on its own does not give you money. It's when you apply your patent, your invention to a product, maybe a drug, and then look at vaccine. Look at how pharma companies are on a race to develop vaccine. And that's what really gives you. And people will look at Pfizer and say, oh, it's a good brand. I'd rather take Pfizer than taking a no-name company that wants to come up with vaccine. This is dealing with your life. That's also where branding comes on. Then you have to compete and look at, or if you look at the branded products as against generic, you find out that because in India, their population is so much, you find out that there are so many generic companies in India making drugs. Their drugs are not fake, they're not counterfeit, but they're a little bit low level. So if, for instance, you take GSK Panadol or take Emzor paracetamol, and then the fever will go down in 2 hours. You can take a generic drugs and you take 24 hours, but the fever will still go down. So these are the things, patents and all those, the legal aspect, the technical aspect, they do not really, all they give you is protection, but economically. So that's why I am keen on her last aspect, which is the commercial aspect. That's where you make the money because you apply those to your product. So for instance, trade secrets. Coca-Cola has been making so much money with the recipe for their Coke because nobody knows. So many people have worked with them, and I will move because my battery is going down. So many people that work with Coca-Cola have attempted to sell that trade secret, but they can't because you don't have it complete. Also, I think trade secrets is for another day, but to quickly say that the fact that you have a trade secret doesn't really give you the protection, but you need to know the people that have access to that trade secret, because Coca-Cola will probably open it up to very, not middle officers, but very, very top officers, very few. And then they have checks. So to make sure that nobody discloses it. And before, for instance, it's just like marriage. You don't go about disclosing all your secrets to an ex-boyfriend, but you can disclose to your husband because if he hurts you, he hurts himself. So that's why the company will look at the people that they expose the trade secret because it's money. That's where the commercial aspect of what Maggie talked about will come in. So you need to protect all of those, and because that's what gives you money. And then you agree on what product to license because it's not just having it. If you have it and you're not using it, license it so that somebody gives you money and they can use it. We have those under NUTAP where you have transfer technology. You have businesses from overseas coming to Nigeria to sell the technology we don't have. And the Nigeria will be paying them money for that and they can exit with the money through central bank and then registering and all of that. So let me see the, yeah, so I was gonna also mention that it's also you look at patient capital in the hospitals. You know, hospitals will be struggling to get you as a patient, a long-lasting patient. Some people are sick, they travel, they're sick, they go to a hospital, or they moved from Lagos island to mainland. Then they go to hospital, they pay, but they're not permanent patients. They leave. But there are patients that have used the same doctor for years. So it's patient capital. So at least the beginning of the year, they can buy equipment knowing that Mr. T and his family at least will be coming to this hospital for 1 year, and then we can budget with that money, that money is coming. The same goes with universities. If you talk about Harvard or Yale and Princeton, those are, they thrive on the number of students that graduate from the school, so they can invest. Their professors are rich because they know these students are paying, because they know when they get their degree, it's a big deal. Companies come even before graduation to take them. Talk about even the business school, that's even there, because these are the business school that turn out CEO for Wall Street and what have you everywhere. Look at the Lagos Business School, the same thing. So these are the things that intellectual property will give you and your brand will give you. You better invest in it, because that's money. It gives so much value that people really don't realize, or even so much so for our Nigerian government, they really do not realize the revenue that the trademark registry is giving them each year, because companies continue to file their trademarks in Nigeria because business is good, and also because of our population. We are a consuming society, we're always buying. Look at when somebody has said to me that Nigeria is like a car showroom, because you come to Nigeria, you see all the new cars that have come up. You come to Nigeria, before iPhone comes out, they already have the iPhone 12. And so we're really a consuming society, even though we're not producing. So business is good in Nigeria. And for commercial aspects, companies are really smiling to the bank. Thank you.
Wow, thank you very much, Ma. So over to you, Mr. Folarin.
Okay, I think just to piggyback, I mean, that last point, Mr. Okocha's last point was spot on. The WTO today, I think, released a statement saying Nigeria is Africa's largest importer. The news item came out maybe about an hour ago or so. So there is truth in the fact that there is business here. And one of the trademark registry, I think, has some low-hanging fruits, because NAFDAC says, for example, before you can get a license or registration for food, drugs, and all that, you must show evidence of brand ownership. So people run their SON, says before you can import XYZ, you must show evidence that you are either the owner of the accepted application or you are the trademark owner, and so people run there. But I think for the average man on the streets, and I like that Maggie talked about the SMEs and startups particularly. I think there are two levels at which there's like a disconnect when it comes to intellectual property and the average African. I think on the first level, there's the cultural level, and then there's the economic level. So while with regards to regulatory compliance in Nigeria, there are regulatory compliance requirements that you must register and you must get some kind of evidence of registration. So what that does is people have to register, but in the absence of those regulatory requirements, I'm very sure that many businesses that operate in Nigeria would not ordinarily register. And one of the reasons is because it's difficult to connect if you don't have that paradigm. If you don't have that paradigm shift, it's difficult to connect IP to your bottom line. Especially when one doesn't operate in maybe a sector that is based on information or intellectual property, like the information technology sector. If what you do is you buy and sell onions, like I told you the other day, I was at Orange Market in Maraba. I went to the client who is looking to provide financial services, to people in that space, and there were millions and millions of nairas worth of onions and all sorts of products, agricultural products. But how do you communicate to these people the fact that you should have a trademark, and so on and so forth? Because for them, there's no connection between, I'm selling, people are coming anyway, and I'm selling out. So what are you coming to tell me? And I told you, in fact, to moving around with my clients, that they had to take off my tie and take off my jacket, and just roll up my sleeves, because you don't want to appear hoity-toity to some of these people. So there's that disconnect. The average person does not connect the IPR, or the IP to their bottom line. And that it says a lot about the nature or the level at which we operate in Nigeria, because many of these people they're not thinking of, okay, how can I introduce technology, to my business? Because once you start thinking information tech, or start thinking, new media, then the reality or the realization of IP becomes, very strong. And I think on a cultural level, I think and this is a theory, this is my theory. My theory is that the African concept of property, like we discussed, that centers around the communal use of property. So the Eurocentric, if you may, idea of property has more to do with an individualistic approach. So it is one man, one woman, and their house. It is being mine. But in the African conceptualization, what you have is an individual who is part of a unit, a family unit, which is then part of a larger unit, and which is part of a larger unit, including your ancestors, because we are never too far away from our ancestors, and our forebears. And then there's that connection through the lineage, in the African conception. So when talking about intellectual property in itself, at least from a Eurocentric perspective, requires some level of quote unquote selfishness or an individualistic frame. You get, and so I think at a cultural level, or at maybe a subatomic level, many people it doesn't resonate with us, in that sense. And that's why I think I was quite tickled when Maggie said that they also have the same recidivist approach to IP, or let's say like a lackadaisical approach to IP. I think it comes from a place of maybe some kind of deep cultural concept, and I think so. The question is, how do we overcome that? This conversation is one of the ways. We need to have more conversations about IP, and the truth is, IP in itself is evolving. Let's say, okay, you say from the statute of Anne, for example, you trace copyright and you trace all the various types of IPRs. If you had a publisher, or if you were to take a publisher from, let's say, from the 15th century and bring him into 2021, that person, or if you were to bring Anne herself, Queen Anne, she would not recognize copyright, in the form that it is today. You understand? So it's an evolving conversation, and I think from the aspect of culture, we should also recognize the fact that culture evolves. Unfortunately, many of our local traditional cultures have suffered a clash, and so a clash with Western culture, and so we find that we are lost. That's why I can tell you, for example, that the average person who buys a pirated CD, CDs are no more a thing now, but the average person who buys a pirated CD does not think he or she has done something wrong. You know, he or she doesn't see it as, oh, I have, by buying this CD, I have robbed the, you know, either the artist or whoever, the software developer, whatever, of revenue. So we don't see it as something wrong, and that's because we have this communal sense of property. Now, quite interestingly, you find in the West, there's also been, I think, over the past couple of years, a growing shift towards a more communal approach to intellectual property, and you find that in movements like I think Professor Lessig's Creative Commons, which is a very strong movement. You find that in movements like Copyleft. You find that in the people who, the open source movement. I think that's also very strong. And Android, the entire Android platform well, let's not say it was birthed, but it became as strong as it is today because it started as an open source platform, or it started on an open source platform. So I think there is some value to the African concept, if you ask me, of intellectual property. And I think it's a good idea that we're having, you know, these conversations, because it should, at some level, help policy, help to shape, you know, our approach to intellectual property, our approach to some of these IPRs. So good one, Maggie. I would like to have a conversation on what the general feel is like on the ground, you know, in Namibia, you know, or what the general response of most people is to IP. And then we shouldn't forget that as IP in itself as a course is, you know, as an area of study or an area of, you know, as a field of thinking in Africa is fairly new. I think what we consider to be IP is maybe the spirits of our ancestors, you know, from a historical point of view. So it's fairly new, and not all universities, I think more universities are teaching it these days, especially at the undergraduate level. But there should be, you know, some kind of intervention, maybe at a much earlier stage, you know, to bring it into the consciousness of our people. So well done, Maggie. I should commend you, and thanks, Juliana, again for, you know, sparking these interesting conversations.
Thank you very much, sir. So I will just say that
I was just gonna say that I agree completely with Folarin. You know, what is the issue with Africa? Also is lack of knowledge, lack of awareness, and poverty, because we actually have lots and lots of brands, intellectual property. We have resources, we have things to really promote, but the government is not helping us, because abroad, when they find out that somebody, or even a startup, the government could encourage, fund them, knowing that that would benefit the greater country. But we're not like that in Nigeria. I enter a shop in America in Whole Foods, then I see Dudu, and they're selling it so high. And I remember when I first started my practice, they came and said, okay, we should represent them. They were having a business with a German company. So you see, that's what our lawyers, we should really open the doors for all of these businesses to come, so that we can advise them and encourage them, because the Western world is really tapping from their resources and the IP that they should be enjoying. They really don't. So that's what we look at. What is happening to Africa, create forums, have what you're doing is good, because people say that, how do you run courses for IP lawyers? This is very good. And then we share the knowledge, and everybody will be aware, everybody will know, and then become an expert in IP. Thank you so much.
Thank you very much, Ma. Another thing that you said is about connecting IP to the money. And I think that's where the issue is. People have not been able to connect how they will make money from registering. So they might say, yes, I know about copyright, I know about trademark, I know about this, but how would I get money from it? So I think that's another thing that is making people not really invest in, that's the IP protection, aside from the poverty issue. So I'll be calling on Paul. Paul. Hi, Paul. Okay, if Paul is not here, I'll just call on Daniel.
Hello, I'm here.
Okay.
I'm here. Okay. Hello, everyone. My name is Akamewan Paul, and I graduated from Amritsali University, and I was called to bar in 2019. I am the founder of Paradigm Stone Attorneys, and I would like to say, first of all, that this is a very great opportunity, and I'm very glad to be here. And so today, my presentation today is on the variables of the economic importance of intellectual property. That is basically, I'm going to be talking about different opinions from different scholars and different authorities. Of course, this topic is a very wide one and something that would not easily be spoken about, especially with the short range of time. And so I'm just going to make a very quick summary about them. First of all, I would like to say that intellectual property law has a great deal to do with the economic importance of the economic value of a country. And one of the most one of the ways in which a country can protect its intellectual property, one of the ways in which a country can protect its technological development is by way of intellectual property. And if you realize, if you take a very good look, you would realize that countries, as regards intellectual properties, countries with better technology do better than countries in terms of growth and development than countries without technological growth. And as a result of this, the need for the protection of intellectual property arise. The need for the protection of your intellectual property rights. Now, due to this this technological development, countries would need to protect their intellectual property to prevent piracy, to prevent IP theft, especially from countries that are closely related and are have easy access into their countries and their countries' benefits. And so it is these countries with better with technologies found a need for their for protection of their intellectual properties, their technological developments, and so forth. Now, I started my. Sorry, I'm trying to get to my work. I want to share my screen.
Okay. It will take time. You can just continue if it would.
Okay. Okay. I started my work by talking about a quote by a scholar. I started my work by talking about a quote by a scholar named sorry, I'm here now. Okay. I started my quote by talking about a scholar Okay, I'm just going to move on. Okay. Okay. A lot of scholars have talked about the economic benefits of intellectual property to countries. Now, some scholars have come up to say that the protection of intellectual property is basically for the idea of monopoly. It is basically for with the intentions of intellectual property right owners, with their intention to protect their rights solely, with the interest of protecting their rights solely, and forgetting the benefits of the populace. That is, forgetting the benefits of non-protecting the rights as regards their opinions that non-protecting, when you do not protect your rights, when you give easy access into your intellectual property, it encourages creativity and therefore benefits the people more. And so some of them have said that, especially in situations of small businesses, I heard somebody talk earlier on small businesses where their intellectual properties are actually just lying to waste and not and of no value as it is. In such situations, they said that when your intellectual property is protected in that situation, it cannot be developed and be made into another form. The idea of spin-off activities cannot be undergone on your intellectual property, and so this would lead to stillness of your intellectual property, especially in situations where the owners of the intellectual property are not even making financial benefits from them, which is also causing a deprivation to the economic value of that intellectual property, especially where the intellectual property is based, the jurisdiction in which the intellectual property is based. Other scholars have come to say that intellectual property has been very beneficial to the other scholars have come to say that intellectual property has been very beneficial to the community, to the people, and to the intellectual property owners. That is in the sense that it helps the creators of the intellectual property to be more creative. It helps the creators, it helps people to think more and then come up with better and new ideas. It helps people to get the value of their creativity. And it helps people get the value of their creativity. Okay, an economic view of this exclusive IP rights, secure to sell, to license, to sell or to license your rights. And as such, owners are the only sellers in the market of their own intellectual property. And it does not go without saying that the businesses that depend on IP rights protection represents an important and growing part of every modern economy. Now, the intellectual property system offers a wide range of tools for countries in different stages of economic development and for different cultural and social economic context. IP is not the drive for a successful economy. Obviously, it is not the only drive for a successful economy, but it is one of the most significant policy that complements the drive for economic success. Now, sectors that rely on IP rights represent significant parts of developing economies, and especially in terms of their gross domestic profits, their GDP, their employment, their tax, their revenue, their strategy, and other strategic importance of the intellectual property. IP rights also promotes foreign direct investment and technology transfers in developed and developing countries. And so, yet we still have some scholars saying that, according to Richard Stallman, he particularly said that the term systematically distorts and confuses these issues, and its use was and is promoted by those who gain from this confusion. Here he was talking about the owners of the intellectual property. According to him, it's only benefits the creators of this intellectual property. And as he said here, its use benefits only those who gain from this confusion. He called intellectual property rights a confusion. He termed it as a confusion. He said he went for that to say it promotes a catch-all to lump together disparate laws, which originated separately, evolved differently, covered differently, and covered different activities, have different rules, and raise different public issues. Here is stating that intellectual property rights has raised different public issues. He he also stated further in paraphrasing now, when he said that copyright protection is aimed towards monopoly. It is not at all a service benefit. It doesn't promote progress in of science, and it doesn't create useful acts. Now, such IP rights what sometimes we know sometimes people protect their intellectual property rights because they can and because it is their own creation. Sometimes they are actually and truthfully financially worthless, in the sense that they do not develop, they do not get or generate any financial benefit from this right, but they decide because it is theirs and they can to be protected. And he's saying here that these activities like this prevent activities where people can come and people can develop a particular intellectual property. People can make your intellectual property into something that is more productive and can always benefit other people aside the intellectual property right owners. But all in all, I would like to round up by saying that intellectual property has been very beneficial to the economy and to different developing and developed economies around the world. Although people still have their own, everyone is entitled to his own opinion.
Yeah. Thank you very much, Paul. I think one of the things that you tried to do was to get the opinions of scholars and how they felt about the value of IP to the economy. But I think it can simply be seen from different, like if you look at those in the music space, you ask yourself, how much has music brought into a country like Nigeria? And how many people have jobs because of music? Aside from just the singing, we have people that are producers, etc. How has this helped people to get daily income? So that's bringing it to simple terms, like people have gotten jobs, people have put their money in the bank, and they've been able to take taxes out of people just in the music industry. And if you look at the amount of money that have come into Nigeria as a result of music alone, even the prestige that have come in to the country, you can imagine Burna Boy and the way he has been able to get the Grammy and all that. People have gotten jobs just because they are connected to him, because maybe they are his managers, etc. So that is one way that it has helped the economy. If you look at the movie industry, you see that there are women and men that have started their businesses in this space, and they have been able to get employment. They have employed a whole lot of people that are producing, people that are doing the editing, people that are acting. All these people have gotten jobs. And if you look at Nollywood has brought in a lot of people into the space, and those people have money also that they have gotten from this. And the government is also enjoying from this. Then if you also look at the tech industry, people are going into robotics. Just when I think Flutterwave said that they were like $1 billion or something like that. And that is also intellectual property, and it has also brought in money and provided jobs for a lot of people. So it's good to look at it like this so that it's easy to bring it down to the normal understanding of everybody you get. So thank you very much for your presentation. I'll be calling on Mrs. Uche to give her own take to your presentation.
Do you know, thank you so much. Do you know his presentation is so detailed that I didn't add anything more, because he covered all the protection and then the views from different scholars, except for the only thing I will add is that we'll follow the law. So we need to look at the provision, what the law says, and then marry it to a practice. And then that's all I can add. He did a very detailed job. Well done. Thank you so much.
Thank you very much.
And we have discussed economic benefits of intellectual property over the value, over and over. So it will be just emphasizing on those points since we have dealt with them. Thank you.
Thank you, ma. So, Mr. Folarin.
Hi, Juliana. Yeah, yes, I think we've talked about some of these issues, and I actually also agree that he took the pains to cite scholarly opinions. you know, I also am not a fan of taking just following things hook, line, and sinker. There should be some level of interrogation. But I think we've talked about that extensively this evening. In fact, it has come up in different forms in the course of this conversation. So I would say, well done, well done. I noticed that he, I don't think I heard from the citations that he referenced. I'm not sure he referenced any Nigerian authorities. I'm not sure if there's any Nigerian reference. That might just be something to look out for maybe next time.
Okay, thank you very much, sir. I think the last person that will be speaking for today is Daniel, and from the assignments that he submitted, I think he'll be talking about something that's it's an ongoing matter right now. That's the risky matter. So please, can you have your presentation quickly? Thanks, Daniel.
Hey, good evening, everyone. My name is Daniel Akinwade. I'm a young practicing lawyer. I actually joined the first quarter session, but I joined very late, so I reapplied to also to learn more, to build more knowledge. But obviously, the few classes or the few sessions I had have actually improved me a lot. I'll be able to work on content, on IP, advise the client on IP. So we will build from that. Today I'll be discussing. I just want to share my slide. Okay, yeah, I think I'm sharing my slide already. So I'll be talking about an ongoing issue. The wise kid issue. I think it's broke out. It made news 2 weeks ago, if I'm correct, where a certain, I can't remember the name now, but there was a tweet that an upcoming artist, Wise Kid, was using the name whose name was similar to Wizkid. Had copied some of the songs of Wizkid in his own album, and also named his album similar to Wizkid's album, Made in Lagos. He made his album Last Giddy Made. And then his album, the Last Giddy Made album was, according to the person, dropped up like over 30 billion naira. And also I was also using the songs of Wizkid to generate traffic. The Wise Kid had actually come out to deny the claims, but obviously the claims has a lot of holes in it. Let me put it that way. But now I said to look at, okay, let's just, although as lawyers we do not speculate, we've been admonished not to speculate. We follow the facts and evidence. But looking at it, it looks credible, but I just want to look at the possible IP infringement. What are the possible IP infringements in having a name that is similar to Wizkid's name, in naming one's album in the music space, similar to a popular, I don't know if I'm, so I don't know if you can hear me, ma?
Yes.
Can you hear me?
Yes, we can. Yes, we can hear you.
Okay. I don't know if my slide is still on.
Yes, I can see your slide. Just go on with the presentation, please.
Okay, so like I said, so I just looked at the possible IP infringements that let's imagine Wizkid wants to go to court, wants to enforce his IP rights. He feels that someone has infringed on his IP rights. What would be the possible IP infringements? First, I think trademark. in fact, should be the most popular for me because one, looking at the name Wizkid, Wizkid, I looked at that because if for unsuspecting music lovers, it's similar. I can't believe that if Wizkid can prove that that name looks similar, and then it can also how will I put it, can also, there's a way it can make unsuspecting music lovers think that Wizkid was Wizkid. So now for trademark, obviously if Wizkid wants to pursue a claim on that trademark or wants to enforce his trademark rights, first he must have registered the name Wizkid. Of course, trademark can be names can be registered as trademark under the Trademark Act. That was under Section 3. That will be a combined reading of Section 3 and Section 5 of the Trademark Act. So before Wizkid can enjoy any protection of the name Wizkid, he has to first have registered that name, Wizkid. And let's also imagine that he also wants to enforce a trademark right on the album Made in Lagos. He also should have registered that album Made in Lagos. Now, for him to also now prove that Wizkid is an infringement on Wizkid or Lasgidi Made is an infringement on Made in Lagos, he has to show that both names are so similar that they can deceive unsuspecting music lovers that Wizkid is Wizkid and Lasgidi Made is also similar to deceive people that Lasgidi Made is made in Lagos or is made in Lagos album. So he has to show that it's not just enough to just register it. He also has to show that the particular acts is likely to be so similar that it will deceive his music lovers or his music fans to believe that that album is his album and that name is the one who is bearing that particular name. Now, let's imagine Wizkid did not register or did not trademark this. Does he have any remedy? Yes, he can also seek remedy under passing off. The common thoughts of passing off. Of course, he has to prove that he has a goodwill, that's reputation, he has a popular reputation. Wizkid has that, and that, of course, the person is exploiting his name to the extent that he's exploiting his name for his own benefits. Now, I also looked at the fact that, I've looked at that. Then now, another interesting aspect that I so much cherish was the fact that passing off under Section 3 of the Trademark Act is also provided under Section 3 of the Trademark Act. That's something intriguing. I mean, for someone who has not registered his name, it shows that his interest, Trademark Act also provides for his interest, even when he has failed to register his trademark under the Trademark Act. Then I also looked at something interesting. Under Section 8 of the Trademark Act, if Wizkid's name was his own name, let's imagine Wizkid was not his stage name of the upcoming artist, it was his own name, then it won't be deemed to be an infringement because that is his own name, his birth name. So that is that under trademark infringement. So another area I looked at is, I hope I'm sharing the right slide. Another area I looked at is copyrights. For copyright has been labeled the bedrock, the foundation of the bedrock of music industry, IP rights in music industry, because it can be used to monetize their music. This is the recreation of an artist. Okay. Sorry. Sorry, hello. I hope I'm still.
Yes, you're still here.
Okay. Yeah. Okay. I'll quickly round up. This is the creation of an artist. So, looked at Section 1 of the Copyright Act. Section 1 provides copyright protection for music lovers. Also looked at Section 5. Section 5. I also looked at Section 5 of the Copyright Act. also look at Section 5 of the Copyright Act. Section 5 also provides for the rights of the artists. In my slides, a lot of them: reproduction, publication, performance, distribution of the works. Then by Section 11 also, the holder of the copyright in the music industry will have right of authorship. Now, the question is, who owns the copyright? Well, it's believed that there are several copyrights in the music work, but originally, the composer of the music work has a copyright for his work once it is expressed. The phonograph or producer also have a copyright to the sound. And once the composer of the work has authorized a performer to perform the work, definitely, which I have also produced as under neighboring rights, the performer will have what we call neighboring rights. So the broadcaster also have copyrights once he has been authorized to use the work. He will have the exclusive right to broadcast, depending on the templates or depending on the assignments, the limitation, if there's any, depending on the assignments of the work of the music work. So there are a lot of rights embedded in the music work. So for me, that would also be a possible IP infringements if it turns out that Wizkid had actually copied these songs in his album. Then I also looked at neighboring rights, yes, which can also be deemed as, or which is also called related rights in some jurisdictions. Of course, there are rights that are so related to copyrights. They're not copyrights, so to say, but they are so related to copyrights. And under our Act, the Copyright Act, under Part 2, Section 23 of the Copyright Act, there's provision for neighboring rights, which is vested in the performer of the music work. So once a performer performs a music work, sometimes in a music work, Wizkid might not be the one who wrote the work, although he might have copyright to it. But the fact that once he performs the work, he has neighboring rights to the work. So, and by Section 24 of, I think Section 24, the performer of the work has neighboring rights, he has exclusive rights to his work. So these are the possible IP infringements that I'll be able to figure out from the possible, if possible, actions of Wizkid relating to Wizkid. Thank you.
Okay, thank you very much, Daniel. So I'll just point out two things. One is that for the Wizkid and the Wizkid, they're actually very similar. So if he wants to sue for infringement, he can do that. That's if Wizkid is in Nigeria, because trademark is territorial. And then for copyrights, copyright doesn't protect the idea, but the expression. So except Wizkid took like lines from his composition, or as in took the way he expressed it, then he might be able to sue for a copyright. But if he totally did a different tune, different lyrics, etc., then he is not infringing on it, because copyright protects the particular expression of the work. So if he took the tune of his song and he also took the lyrics of his song, then he can sue for that. But aside that, it would not fly. Mrs. Uche, please, you can comment further on it.
Yeah, thank you so much to our very last presenter. I'm so happy that we'll be rounding up shortly. So, he did mention that if Wizkid is able to prove, he doesn't even need to prove anything, because his fans will prove it for him. Wizkid is so well known, he's almost an influencer. Remember when we started the End SARS, it took one statement from him, to something. So the only defense that Wizkid has is if his parents named him Wizkid, and then it's also generic, because that means he can't even register the name Wise Kid, because it's, how did they say it in law? It's the Part B of the Trademarks Act, which is descriptive. So if you say that you're Wise Kid, almost every family has a Wise Kid. So he can't even claim protection for that name. But Wiz Kid, on the other hand, is so well known that this Wise Kid too, if he tries to come under 13.2, which is innocent concurrent, that, for instance, that he registered the name Wise Kid, or he started using the name Wise Kid innocently, because either he was named Wise Kid or he started using it without knowing of the existence of Wiz Kid. It's not possible. Clearly he knew. So there's nothing innocent about this move. He really wanted to reap where he did not sow. He saw a name that is so popular and wanted to cash in on it. So he really has no defense. And Wiz Kid has little or no expectation, for him to come and prove his case. It's so clear that this guy was trying to infringe on his rights. And there's also, I don't know the meaning of Lasgidi. You say it's made in Lagos. I don't know what it means. What does that mean, Lasgidi? Because there's a...
No, I think Lasgidi, for me, I actually don't know the meaning too, but it can be interpreted to be maybe something that has to, an emblem of Lagos or something that represents Lagos. But Lag should mean Lagos, I guess.
Okay. Okay, if that be the case, he will be fighting on different fronts, because Lasgidi, he can't even claim if it's like, because it will be like Eco, how you say that you have Eco Bank, you have Eco Hospital. There are things that are common words used by Lagosians that no person can claim monopoly. So you see, what he has really is, and then there's a restaurant, if I'm not mistaken, in Lekki called Lasgidi already. So you can't stop them from using it. But this whiskey thing is really very, very, it's clear that he wants to claim, he wants to, what's the word? He wants to enjoy the reputation already established by Whiskey. So that's my contribution. Thank you.
Okay. Thank you very much, Ma. And thank you to all the mentees that presented today. Everyone has learned a lot. So we would be expecting your assignments for next week. Brandon rose up his hand to ask a question, but it's already late. So if you can send your question, then we can forward it to any of the mentors that it's addressed to. And then a WhatsApp group will be created so that information can be passed easily. I want to say a very big thank you to Mrs. Uche for staying till the end. We are so grateful. And thank you for Christina that also came. She's also an anchor. Thank you very much for joining us. Thank you, Mr. Folarin. Thank you, Mr. Marx. See you all next week, Friday. Thank you very much.
Thank you so much. Bye.
Bye, Ma.
Bye.
Bye, everyone.